same person.
We've reached 47.
Yes.
And we've reached 5-3.
All the best, Gregory. All the best, Anil. Take care.
Thank you, sir. Shall we start?
Yes, you can start, Anil. You can start now.
Okay. Friends, good evening and namaskar. On behalf of Nivaran, mediators of the Supreme Court of India, I welcome you to the 9th and the final day of the International Virtual Mediation Summer School 2022. My name is Anil Shrivastava. I am an advocate and a mediator in the Supreme Court of India. Over the course of the past 8 days, you all have attended and have heard many esteemed law professionals speaking on diverse subjects, topics like the historical perspectives of dispute resolution, the ethical issues involved in mediation, communication skills, the difference between mediation, conciliation, arbitration, and litigation, developing negotiation skills, and online mediation. The topic for today deals with the policies, conventions, legislation, all which are behind mediation, and what lies in the future for mediation. The topic for the day is divided into 3 sections. First is the future of mediation. Second, and very important, the Singapore Convention. And third, legislation and mediation. Speaking on these topics and sharing his vast knowledge and expertise as a law professional is our guest speaker, Mr. Gregory Vijyendran from Singapore. Welcome to the session, Mr. Vijyendran. Mr. Vijyendran is a lawyer admitted to the Singapore bar in 1993. And if I were to speak on his entire gamut of expertise, the innumerable awards conferred upon him, the research papers he has written, and the landmark cases he has been associated with, it will fill up many a pages. So I will briefly introduce him to you. As I said, Mr. Vijyendran is a lawyer and a partner of the law firm Raja and Tan at Singapore. He has considerable experience and expertise in various spheres of civil and commercial litigation and arbitration and dispute resolution. His present practice encompasses a specialization in banking and corporate insolvency and a broader dispute resolution covering company, contract, tenancy, employment law, defamation, negligence, and tort claims. He has won and been conferred with innumerable awards, but 2 awards really stand out. The one was conferred by the Advocates International in Washington, D.C. in the year 2008, and it was the Good Samaritan Award. Now, you don't hear of many people getting the Samaritan Award. And our speaker for the day has been conferred that. He has also been conferred with the inaugural Pro Bono Ambassador in 2009, conferred by the Law Society of Singapore. He presently serves as the President and Executive Committee member of the Singapore Academy of Law. He is also on the board of the Singapore International Mediation Center, and probably the best person we could have to speak on today's topic, that is on the Singapore Convention. He is also a silver medalist in international chess. So that's a very, very great achievement. He has been judicially commended by the highest court in Singapore in 2006 for meticulous professionalism. So those are our speaker's achievements and the awards conferred upon him. Now, before I hand over the session to our guest speaker, on behalf of Nivaran, let me share a few thoughts on the topics for today. As regards future of mediation, almost all jurisdictions agree that mediation is to be the accepted dispute resolution mechanism and not the alternate dispute resolution mechanism. The reason being that it is voluntary, it is confidential, it is cost effective, it is fast, most important, it is non-adversarial, and even more important, that it helps preserve the relationships among the parties. As far as the future of mediation is concerned, in India, our first court-annexed mediation center was set up in April 2005 in the Madras High Court. And in the course of the last 17 years, most of our district courts, all our high courts, and the Supreme Court have mediation centers, number of lawyers practicing and working as mediators, doing a very, very good job. But if mediation is to become more popular, if mediation has to become the first stage in dispute resolution, it has to move out of a court-structured mechanism. It has to move out of a mechanism wherein parties have to first approach the court, raise a dispute, be referred to mediation. The mediation is either settled or it is not settled. If it is settled, then you go back to court for the enforcement of that settlement award. What is really required to popularize mediation and to make it effective is that you need to have a standalone, dedicated mediation act. Most countries need to enact legislations which are solely for the purposes of mediation and so that litigants don't have to go to courts. Countries need to sign and ratify the Singapore Convention. Now, why countries should sign and ratify the Singapore Convention? Why is it so important in the field of mediation? As I said, we have a member of the board of the Singapore Mediation Convention, and he will be speaking to you on this. I will not take any of your time on the Singapore Convention. As regards legislation and mediation, well, let me tell you that the Mediation Bill 2020, as far as India is concerned, the Mediation Bill 2021 was introduced in the Rajya Sabha in December 2021. And the Rajya Sabha referred the bill to the department-related Parliamentary Standing Committee on Personal Public Grievances, Law and Justice. And the said committee submitted its report, which was presented to the chairman of the Rajya Sabha, and the honorable chairman has forwarded the said report to the honorable speaker of the Lok Sabha in July 2022. We are hopeful that Parliament would find time to pass this very, very important legislation. Now, what is it that the Mediation Bill 2021 provides? Now, what it really provides is that there shall be compulsory pre-litigation mediation. It also provides that in exceptional circumstances, a party can seek interim relief from the court or the tribunal before the commencement of the mediation proceedings. It also provides that for enforcement or challenge to the settlement which is arrived at in the mediation session, parties have to approach courts having the territorial jurisdiction. It also provides for giving a more legal structured shape to online mediation. It also provides that the mutually settled agreement can be challenged on very limited grounds of fraud, corruption, impersonation, and there is no first appeal provided for in the bill. However, there is one provision in the bill which is a cause of concern as far as we as mediators are concerned, and that is a provision in the bill which says that other than commercial disputes, the central and the state governments will not be party to mediation in other disputes except for these commercial disputes. So therefore, the message being sent across by the bill is that as far as India is concerned, India's biggest litigants, that is the central and the state governments, will not be a party to mediation, will not accept mediation as a dispute settlement mechanism. Now, this is really a cause of concern. If we are to reduce the burden on our courts, if we are to cut down on our areas of cases, India's biggest litigant cannot be kept out. Now, I'm glad that the parliamentary subcommittee has flagged this very issue, and in its report, it has said that this provision should be amended or done away with. And as a matter of rule, governments, the state government, the central government should be party to all disputes. And as far as mediation is concerned, and only in exceptional cases should mediation be kept out of those disputes in which the government is a party. Now, I hope Parliament accepts this suggestion of the parliamentary subcommittee, and we have the central government and the state government being party to mediation settlements. With those words, I now hand over the session to Mr. Gregory Vijyendran, and to the participants, please you feel free to raise questions, put them on the chat box, raise your hand, and subject to the constraints of time, we will try and take as many questions as possible. Vijyendra sir, your session.
Thank you very much, Anil, for those kind and rather lengthy words of introduction. I would have been content with maybe 10% of that, but it was just very kind and generous of you. Good evening, dear friends from all over the globe. Good morning and good afternoon too. It probably is a very different time zone in different parts of the world that you're zooming in. Just before I begin, I mean, Anil made a reference to my former chess playing history, and I want to say congratulations to India for their fine performance in the recent Chennai Olympiad, the women's team winning the bronze medal, and India hauling, I think, a massive number of medals, which is a really superlative achievement. My first tournament was actually in India, and I was slaughtered by Vijyendran in about 30 moves. So that's history for you. But anyway, let me not digress. This evening, it's my privilege to speak to you about the future of mediation in this final lecture. And, you know, it's in some ways a peek or a peer into the future. And based on my remit, what I have structured this evening for our Indian friends and different time zones for the rest is really three distinct aspects. First, online mediation, drawing from very practical, very anecdotal experiences that I've had as well as mediator, and you know, also based on some of the analytics of online mediation. And so I see the future of mediation being very much wrapped up with online or virtual mediation, although I will conclude with some other observations on that particular aspect of prognosticating trends into the future. Then in the second segment, I will focus on the Singapore Convention on Mediation. And the third, I will touch on three observations on legislation, again, drawing from Singapore's experience about enabling legislation, and some of that perhaps might have broader wisdom I was very keenly taking notes on what Anil described as the update for India as well. Very heartened to know that in July 2022, the mediation bill has now been presented to the Lok Sabha, and looking forward to the continuing developments on that front. Now, let me share screen right now as I begin my topic. And so I'm speaking about the future of mediation. And so the first part I'm going to touch on is on online mediation, and two broad spheres. First, advantages, and secondly, on issues. And so beginning first with the question of advantages, and trying to share a little bit about that aspect. And you're going to have to bear with me because I'm just trying to get into the slide presentation here. Okay, so first advantage that I want to touch on for online mediation is its agility and nimbleness. Many of us have experienced the severe restrictions due to either pandemic lockdown or travel restrictions, and have adjusted to a new normal. Masks are only part of it. And clearly we have become more adept, more agile, more nimble with tech, and pivoted online. I was a skeptic at the start of the pandemic when the idea was mooted about using tech for our mediation services for the Law Society, which I was then leading, Law Society of Singapore. By the time the pandemic ended, I was a convert. And the reason for that was the effectiveness that I saw with online mediation, and with the modality involved and its efficiency as well as effectiveness in resolving disputes at the hands of skilled mediators. And the potential is there for us long after the pandemic becomes a footnote of history. And so you would need tech infrastructure. In my view, it is one of the sustainable innovations that came out of the pandemic. Necessity being the mother of invention. Is an innovative tool to ensure access to justice, especially real time and synchronously. Apart from agility and nimbleness, the other advantage is there is no geographical limitation. So that makes it perfect for cross-border disputes, as well as for disputes that might even straddle different legal systems. For instance, where you have a party from the common law world and another party from the civil law world. And I will share an anecdotal experience of a co-mediation experience that I have, which was precisely that, where we were able to navigate a particular dispute with an Indian party on the one side and a Japanese party on the other. And it also could entail the bridging of cross-cultural differences and nuances. Third advantage, cost savings and time savings. And this is intuitive. You can actually facilitate easier scheduling by parties, counsel, and the mediator. For the institutional client that may be a party to a dispute being submitted to mediation, the decision maker, who probably would be very much working in the business and on the business, could be zoomed into the meeting at critical junctures in order to be able to either give an appropriate mandate to the party that he is a chairman of, and also perhaps even to break the impasse at a certain juncture. There are reduced travel costs, venue costs, and time, not forgetting the fact that you won't get jet lagged if you're traveling. Now, it's also logistically efficient because there are breakout rooms for parties and counsel. And that's the beauty. You can create as many rooms as possible. You can customize it. It's bespoke. You could have a mediator's room, a mediator and counsel room, and you save real estate You don't need physical rooms to be able to achieve that goal. Fifth advantage, you can, through online mediation, achieve teamwork and even neutrality in cross-border disputes. How do you do this? By appointing co-mediators, for example, one by each institution or each jurisdiction, who will then collaborate and bring about that resolution. And that was the wonderful story that I will share with you in a moment, co-mediating with a Japanese mediator. Now, the importance, though, when you do this is that you need to speak with one voice. It must be loud and clear. It's got to be consonant. And trust and teamwork is vital among co-mediators, but you can bring in the best of both worlds. Now, the other advantage, of course, for online mediation, and this is operating on the assumption that everyone plays by the ground rules, no recording, no stealthy, surreptitious trying to capture the proceedings by way of video, audio, etc. And this advantage is one of confidentiality and candor. And it's true both for on-site mediation, it's also true for online mediation. And it enables matters raised in the mediation being kept strictly private and confidential. This is one of the great advantages of mediation as a general dispute resolution tool. And with that confidentiality, you will promote frankness and forthrightness in communication, because people want a safe place to be able to share with openness about their interests. It's an optimal tool also for reputation management, where you don't have news of that dispute being splashed across media, whether it's print media or whether it's in the cyberspace. And there's a confidentiality about that, which makes it a ripe as well as a right tool for reputation management. It's also in the context of Asia, where face is so important to so many cultures, a face-saving way to achieve a win-win outcome, so that nobody needs to feel like they are a loser. And in litigation, as we know, in many occasions, it's a case of a winner and a loser. So true also for arbitration. And so this allows both sides to walk out as winners. In that sense, it gives an avenue for a face-saving way to achieve that. Now, the seventh advantage, and in that sense, the final advantage that I will touch on is psychological factors. It levels the power dynamics between the parties. For example, individual versus institution, the multinational corporation versus the small and medium enterprises. Why? Because we're all reduced to a single square on a grid. And so there's a great leveling about the power dynamics. As an anecdote, someone shared how, it's like when you see everyone on virtual, we all, just see the face and we assume so many things about the physique. And then you step into a physical meeting with the individual, realize this person is so much taller or so much larger than you, or, and so on, and that takes some adjusting. But, the point is there is a leveler through online. It reduces tensions and temperature as well between parties, which is helpful for some disputes, because you're not in the same physical room where sometimes, it can lead to a provocative situation, either because of the closeness being too close for comfort, some historical baggage or some emotional wound, which is not so easy to deal with in-person dynamics. And I found that, certainly when it comes to some disputes, both the geographical distance afforded by tech, as well as tech as a safe space or sanctuary, allows some degree of not only objectivity, but it allows an opportunity as well for parties to be essentially quite calm about being able to talk about their dispute, even when invited to do so. And so it's important where relational fallout between parties is a theme, where there's strong emotions involved, etc. And I'll raise a further point as well. Could the virtual space be a safe space or sanctuary for catharsis? There is a feature about catharsis that I've shared in a lecture in China, and the power of catharsis in mediation that could be unlocked. And without allowing emotions to turn the mediation into something dysfunctional or to see a toxicity come out of it, there is a power in sometimes venting. And by this, I mean more in the breakout rooms, rather than allowing the emotions to spill over into the joint sessions, which sometimes could then lead to the mediation becoming pear-shaped. So there you go, 7 advantages of the online mediation, which in my respectful submission is going to be a key trend for future of mediation and for future mediation modalities. Now, what are some of the issues that we need to traverse though? First issue is the comfort levels of all participants. Clearly, the fundamental glue that holds any relationship together is trust. And so the mediator needs to work with the parties as well as the counsel to ensure that trust and the relationships are built from the onset. And so that the chemistry becomes key. And drawing from my online mediations that I've presided over, that means a heavier investment in pre-mediation meetings where feasible. You invest the time, you invest the effort, you get to know, the individuals involved in a better way. Of course, it can never replicate the real-time dynamics, but it's the next best. And if you do that, then people are a bit more comfortable, both with the mediator as well as with each other, even before the mediation begins. And you're not going in as total strangers. The second issue that needs to be tackled is parties and lawyers' mindset. There needs to be a specific education about the nature of mediation, which is very different from adjudicative dispute resolution. And you've heard a number of lectures in the course of this summer school, which would have teased out some of those differences. But to ensure that any lingering residue of misperceptions or misunderstandings about mediation are dealt with, you could use the pre-mediation session and even the initial morning session, which is what I do, to try and reinforce what mediation is and conversely what it is not. And it is important for everyone to be on the same page in terms of good faith, candor, process, the language used, as well as the outcomes. And that's part of the socialization that needs to take place, or the education piece, both in terms of the pre-mediation as well as the mediation. For instance, as you would have heard about, the heavy focus on interests rather than on rights or obligations. The next issue is a lack of effective communication. Could someone say that, well, we may not be able to communicate as effectively? There is a truism about it because, we also will be communicating non-verbally when we meet up with one another. Just like now, if you're not seeing my body language, you're just seeing my head and my face, in the course of this lecture. And so there is a lot more that we would be able to absorb and process in non-verbals, but it could be overrated. There's a truism, but it could be overrated because we can use tech tools in online technology to communicate the way that we have, using the not only speaking function, but also the chat function and so on. And what may be a potential solution for effective communication is a proactive engagement by the mediators of parties or counsel, as well as to include them. The fourth issue is the involvement of all parties. It needs to be inclusive. It needs to be even-handed. You need to ensure that you don't have a single party or a few parties dominating the proceedings. And so you need to ensure again, and the solution is similar as that postulated for the previous issue, proactive engagement of parties or counsel, and the mediators need to be alert and to ensure that everyone has a chance to speak. Of course, a practical feature is that, to ensure that everyone is on mute and then to invite them to speak at the appropriate juncture. And that creates a discipline in itself that might also prevent this type of OB markers being crossed in terms of the dynamics. Now, what about tech know-how? What if you don't know how to use tech? Well, it's not the end of the world. There are solutions. There could be tech training, for instance, by mediation institutions. Would encourage Nivaran mediators to also think about that. But certainly a number of mediation institutions, such as the Singapore International Mediation Center, of which I'm part of in terms of the board, as well as other mediation institutions, do pay attention to this aspect. And you can learn basic tips and tricks of using online tools. If not, you could ask a more tech-savvy team member to help. Now, that would be the last set of issues that I wanted to traverse. And now I will share on my online mediation. This was a case under the Singapore International Mediation Center and the Japan International Mediation Center protocol, and it was the pioneer case, the inaugural case of its kind, a dispute between an Indian party and a Japanese party. I was appointed as one of two co-mediators, the other being a very seasoned veteran Japanese lawyer. And it was an exemplar. We were slated for 3 days. We completed and were able to facilitate a successful outcome in 2 days. There were lawyers on both sides. It was a commercial dispute, a high-powered Indian team, high-powered Japanese team of lawyers. And you could see the advantages of mediation because the parties were able to zoom in from their own home. In the case of one of the parties in India, that party was in their home, and so we saw these types of advantages, and you can imagine how this was tremendous from a time saving and even a scheduling point of view. Now, we spoke, my co-mediator and I, with one voice. We were intentional. There was a moment at one stage when I think one of the parties had asked if we would be the mediator to that party, as it were, a mediator advocate for that party. And we were intentional to say that, no, we will be doing this in unison. Together, we will be present together, speaking to both parties in their breakout rooms, not breakup rooms, but breakout rooms or private caucuses, as well as, jointly. And we ensured that, that we were doing this as a team. There was a high level of trust and chemistry. And you can imagine how also the advantage of having two mediators drawing from two different jurisdictions, in my case, a common law jurisdiction, in the case of the Japanese mediators, civil law jurisdiction, we were able to bring in that sense, the best of both worlds from an education point of view, as well as to, socialize that with parties that may not be familiar. For example, in my case, with the Japanese party, being able to at least educate them a little as to, the common law world. And then the advantage of my co-mediator was speaking in Japanese to the Japanese party. So, we were able to achieve this only because there was also a very positive approach and attitude on the part of everyone involved, the parties, the council, everyone was committed to trying to solve the problem. And we were able to do this through that combined mediation, which illustrated for me an amazing experience of collaborative mediation in a commercial cross-border dispute that was able to navigate all the cross-cultural nuances and even the various systems, legal systems that were involved. So that is also an additional dimension of online mediation that I believe is here to stay. And you can consider that for cross-border mediation, having a mediator from that other jurisdiction. One of the ideas that I have mooted in an ASEAN setting is where and this is, as the Law Society president together with the Bar Association presidents from ASEAN, that if there is a dispute between one ASEAN country and another, you both appoint a mediator from each country and the two co-mediate and resolve that dispute. And so no one needs to feel that, for example, the single mediator that hails from jurisdiction A would be siding with jurisdiction A, because now you have the chance for your own mediator to also be appointed, jurisdiction B appointing a separate mediator, and the two of them are collaborating. Now, moving on to the Singapore Mediation Convention, let me begin by sharing about the background to the Singapore Convention. This is the second part of my lecture. Now, firstly, we know the benefits of mediation. You've heard that. You've probably had multiple reinforcements in the course of this course. Flexible, saves time and costs, preserves relationships. It can facilitate trade, commerce, and investments. But the key obstacle for many, many years was enforceability. This was always the boon offered by court orders and arbitral awards. But for mediated settlement agreements, the lack of mechanism for cross-border enforcement of mediated settlement agreements was a massive limitation. And so how would you ensure enforcement prior to the Singapore Convention on Mediation? You would enforce it by virtue of the law of contract. You would enforce settlement agreements as a compromise under contract law, but that proves complicated, burdensome, expensive, and time-consuming. There was a need to examine this Achilles heel of mediation to find a solution, and especially because other features of mediation were highly satisfactory to the users. For example, a Gaultier's study published in 2013 in the International Law Practicum showed that both settlement and satisfaction rate of mediation on commercial disputes exceeded 80%. And so the UNCITRAL Working Group 2 Dispute Resolution, WG2, worked on instruments for mediated settlement agreements to be easily enforced across borders. And in December of 2018, the UN General Assembly, after all the hard work of the UNCITRAL Working Group 2, adopted the convention and slated the signing ceremony to be held in Singapore. And that was the Singapore Convention on Mediation. And this beautiful picture that you will see here on the 7th of August, 2019, with various heads of state. 70 countries attended, 46 countries signed the mediation treaty. And compared to the New York Convention, albeit the New York Convention taking place in a different time, different place, different context, that started with 10 signatories when it first opened for signature. And here you had 46. I was sitting there in the audience and I was just very moved. It was a powerful statement for multilateralism and a high point in the pre-pandemic year in my respectful submission. Now, what were some of the primary aims of the Singapore Convention? To recognize the benefits of mediation, encourage its growth, facilitate international trade, contribute to harmonious relations. And here's a snapshot of the countries that have signed, which remains true both for countries that have signed and countries that have approved or ratified in terms of the numbers that you see on this slide as of August 2022. So it's correct as of to date. 55 countries having signed, 10 countries having approved or ratified, with the latest being Kazakhstan. And we're very pleased, obviously, that China and India both were present for the signing ceremony that you saw and signed. Now, Minister Edwin Tong, who is our second Minister for Law, in his lecture on 17 October 2019, entitled Singapore's Voyage Across the World Map of Mediation, Past, Present, and Future, made a very perceptive point that the significant support by countries coming forward to sign the treaty is a surrogate marker for the country's business interests, because it is driven fundamentally by the country's business interests. The need for a more efficient, effective modality for dispute resolution, or to borrow Anil's words in his opening, it's not an alternative dispute resolution, it's actually an appropriate dispute resolution. Now, this is a picture of the team that were hard at work in bringing about the Singapore Convention on Mediation. So this is the UNCITRAL Working Group 2. And let me touch on some of the key provisions in the convention. So this is the preamble, the recognition for the value for international trade on mediation for settling commercial disputes, noting that mediation is increasingly used in international and domestic commercial practice as an alternative to litigation, and then considering that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice by states. And there was a clear, convincing that had taken place, that the establishment of a framework for international settlement agreements resulting from mediation that is acceptable to states with different legal, social, and economic systems would contribute to the development of harmonious international economic relationships. Now, if we look at Article 1, there are carve-outs. It does not apply to settlement agreements pertaining to personal, family, or household purposes, or relating to family inheritance or employment law. So the subject matter that I've just stated is not amenable for mediation purposes, and oftentimes driven by policy considerations. Now, it also does not apply to the settlement agreements which are enforceable as a judgment or are enforceable as an arbitral award. And so Article 1.1 would essentially surface three aspects that would be the themes of the mediation that would be culminating in a settlement agreement that results in enforcement for the purposes of the convention. And that is where it's commercial, where it's international, and where it's in writing. And you see all of those features right there in Article 1.1. And moving on to the definitions in Article 2, that a settlement agreement is in writing if its content is recorded in any form. And so this gives a lot of flexibility. The requirement that a settlement agreement be in writing is met by an electronic communication if the information contained is accessible so as to be usable for subsequent reference. So there's a recording in a form that can be retrieved subsequently. And so there you have an illustration of a form of the settlement agreement being in writing. Now, and then you see in Article 2.3 the nature of mediation that's recognized, a process, irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons, the mediator, lacking the authority to impose a solution upon the parties to the dispute. And so it's essentially an amicable settlement of the dispute with the assistance of a third person or persons referred to as the mediator, who would lack the authority to compel or to impose a solution upon the parties to the dispute. Now, moving on to Article 3, and here in Article 3, you see two hemispheres. The first hemisphere being a sword, and the second hemisphere being a shield. Article 3.1, that each party to the convention shall enforce a settlement agreement in accordance with its rules of procedure and under the conditions laid down in this convention. And so this gives a cross-border framework for enforcement. And that creates the sword element where you need to enforce. And intuitively, that makes sense, because if you have a mediated settlement and one party is overseas and they renege for whatever reason, you want to be able to take that mediated settlement agreement and to enforce it pursuant to the convention in that country. And so that's the sword aspect. Now, the shield aspect is in Article 3.2. If a dispute arises concerning a matter that a party claims was already resolved by a settlement agreement, a party to the convention shall allow the party to invoke the settlement agreement in accordance with its rules of procedure and under the conditions laid down in this convention in order to prove that the matter has already been resolved. And so you can set up the settlement agreement as a defense, as a shield, to ensure that you will not be sued twice over, or that the subject matter that has already been successfully mediated will not be resurrected afresh via arbitration or litigation. And so therein lies the shield and the sword aspect encapsulated in Article 3. Now, in addition, you've got Article 5, which is essentially various grounds for a refusal to grant relief under the convention. These are recognized heads. Incapacity, where you cannot have the capacity to enter into the settlement agreement, which again follows on from the contractual feature of settlement agreements, the capacity to contract, where the settlement agreement sought to be relied upon is null and void, inoperative, or incapable of being performed under the law to which the parties have validly subjected it. And so it's null and void. Thirdly, where it's not binding or not final according to its terms. And so in a sense, if there is no final resolution of that dispute, it's only an interim resolution, or it's merely an agreement to agree, which is unenforceable, even in contract law, you would have an issue in terms of this ground that might afford relief to a counterparty, or where it's been subsequently modified. And so you have a variation which then becomes a game changer and will also afford a reason for refusal to grant relief. In addition, where the obligations in the settlement agreement have been performed, and so, for example, a monetary obligation that's been satisfied, or where they are not clear or comprehensible, where you have a situation of uncertainty about what the intent is, and you cannot discern that, from the language used by the parties. It's unclear, it's incomprehensible. Then you have a situation where granting relief would be contrary to the terms of the settlement agreement, or a serious breach by the mediator of standards applicable to the mediator. So, for example, where the mediator, contrary to what we saw earlier, tries to impose a solution on the parties, And so there you have a situation to beware, because that could be relied upon by the party that may have felt compelled or shoehorned into a settlement, or has been, from their own narrative, being foisted with compromise that they didn't agree to voluntarily. They could set that up, and that would be an issue, as a potential issue even for the mediator from the point of view of reputation as well. Then you have a situation where, again, it's a mediator misconduct situation, failure to disclose circumstances that raise justifiable doubts about impartiality or independence, and that, that failure to disclose had a material impact or even an undue influence on a party, without which that party would not have entered into the settlement agreement. And then the next 2 points are, very much self-explanatory, where it's contrary to the public policy or not capable of settlement by mediation. Now, a broader point for state parties to the convention, that it may declare that governmental agencies could be excluded. And so I was listening with interest also to what Anil was describing about the one provision where state governments may not necessarily be a party to mediation, and how that particular provision, is certainly something that could be controversial, and the parliamentary subcommittee has flagged it as well. But here you see a situation where there is also declaration for exclusion to the extent specified in the declaration. You've got an opportunity where you could have an opt-in provision that the convention only applies to the extent that the parties have agreed to the application of the convention. And then thirdly, the observation here that no reservations are permitted except those expressly authorized in the article. Now, let me just make a final roundup point about the Singapore International Mediation Center. This is a not-for-profit institution. This is what I hail from. Some of the slides that you saw on the Singapore International Mediation Center were kindly prepared by my colleagues there. It's a not-for-profit institution specializing in mediation of cross-border commercial disputes, launched in November 2014 by our Chief Justice and Minister for Law that you see in the picture there. And it has an international panel of 69 mediators across 17 jurisdictions, with specialist mediator panels from various countries. Now, I did say that I wanted to make a few observations about the legislation. So let me make 3 points about legislation, and basically leave them with you by way of some thoughts or reflections on what you could also imbibe into your own domestic legislation. So the first point is the clarity that is needed on the definition of mediation. I had shared with you the definition of mediation in Article 2.3 of the Mediation Convention, that it is a process, irrespective of the expression used or the basis upon which the process is carried out, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons, the mediator, lacking the authority to impose a solution upon the parties to the dispute. Now, in the legislation that gave teeth to the Singapore Convention on Mediation, which is our Singapore Convention on Mediation Act, Section 2.1 has this definition of mediation. Mediation means a process, whether referred to by the expression mediation or conciliation or any term of similar import, by which the parties to the mediation attempt to reach an amicable settlement of their dispute with the assistance of one or more third parties, called in this act the mediator, and in which the mediator lacks the authority to impose a solution upon the parties to the dispute. And so you see there reference to conciliation as well, expressly referred to in Section 2(1) of the Act. Then we have a domestic legislation called the Mediation Act 2017. Section 3(1) has a lot more flesh to it. It says mediation means a process comprising one or more sessions in which one or more mediators assist the parties to a dispute to do all or any of the following with a view to facilitating the resolution of the whole or part of the dispute. A, identify the issues in dispute. B, explore and generate options. C, communicate with one another. D, voluntarily reach an agreement. So if you compare and contrast these various definitions, you can see that, that for the purposes of the convention, it needed to be, in a sense, in the lowest common denominator, because you're trying to forge an international consensus. So you cannot get, overly prescriptive. And so likewise, the Act is also a looser and less prescriptive definition of mediation compared to the definition I just read to you from our Mediation Act 2017. But what is important is to capture the essence in your domestic legislation of what mediation encompasses. And the key features are amicable settlement via a third party neutral who has no power to impose a solution upon the parties. The second observation I have is this: the enabling legislation that we have, the Singapore Convention on Mediation Act, is silent in respect of applications to stay proceedings in the Singapore courts in favor of mediation. And so we have to fall back on our Mediation Act 2017 should a party to a mediation agreement that may be faced with a situation where the counterparty tries to litigate in breach of a clause that requires that counterparty and the original party to mediate that dispute, from litigating it. And so if you have a mediation agreement, both sides have to submit it to mediation, but you have one party, then trying to steal a march by filing court proceedings. What can the other party do? They could apply to court under our Mediation Act 2017 to seek a stay of those proceedings. And so you would do it either under the legislation or in the absence of legislation. One other thought is via common law principles, where, for instance, the parties have agreed to mediate, and so they need to honor that bargain. Likewise, if the mediation is one tier of a multi-tiered dispute resolution clause, but we won't get into the intricacies of that unless there are questions. Third observation is that the requirement in our legislation is that there is a settlement agreement that is born from the mediation process. So that international settlement agreement must be born from the mediation process before it qualifies to be recorded as an order of court. And that, again, prevents abuse because if you do not have a requirement that the international settlement agreement is born from mediation, then essentially it is taking a contractual agreement where parties have mutually agreed, to rights and obligations, and using the device of the act to have that converted into a court order. And so the abuse that is very much safeguarded against by our legislation is for private contracts to be mutated into enforceable orders of court. It must be pursuant to a mediation process. And so those are the three observations that I have. And essentially, I leave you with a final set of points on mediation. And this is from the last slide that I have, which I'm going to now try and share screen with all of you. And this is my last slide. Why the the future. And here I have touched on the growth of online mediation and why I consider that to be a trend that is here to stay and that is sustainable, and that we would do well to be equipped in every aspect on that. It may be a case also of hybrid mediations emerging in future, perhaps for more complex disputes where the parties might do in person, and because of scheduling issues or because of other reasons, you might have online for other parts of it, or perhaps even part of the day in person and part of the day online. And you might see these types of interesting models. Then I shared my experience anecdotally of collaborative mediation, and I would encourage you to think about that as well. And that is, again, very much a partnership model, a teamwork model, one where you could bring even different personalities with different strengths, specialist and a generalist, someone who may be strong on the portable skill of mediation and working together with someone with industry knowledge in a specialized type of dispute. And then the third point I have here is specialist mediation. This is, in my respectful submission, also a trend to pay attention to in future. As mediation grows, there will be a greater sophistication in the market. And I think some mediators will be sought out because you have specialist knowledge in some subject areas, for example, intellectual property, or say the oil and gas industry, or for instance, when it comes to the cryptocurrency, and that expert knowledge, that type of industry expertise would actually give you an edge, and would actually put you in pole position in terms of trying to mediate some of the disputes that may occur in that space, because you essentially would have the advantage of not starting from ground zero, and you could actually understand the subject matter in a far more quicker way and in a far more profound way than, say, a newbie in that particular area. So I wouldn't underrate the generalists. I am a generalist myself, but I do believe that there is a trending that is here to also stay in terms of specialist mediators being sought out. And I'll give you an example. Earlier this year, I had a successful mediation of an intellectual property dispute before an intellectual property expert, one of our senior counsel who is appointed honoris causa, and she is an academic in the university, and she was able to facilitate a successful outcome. I was counsel in that case, and all the more so for other areas that we may immerse ourselves into. Now, in conclusion, before the question and answers, let me just add my own weight to mediation as the appropriate dispute resolution. Mediation is a value that is deeply embedded in the Asian way of doing business and the Asian way of resolving disputes. Based on an influential survey conducted in Singapore, all the reasons for selecting dispute resolution and this particular dispute resolution, which is mediation, showed that the top reason for users when they selected that modality of dispute resolution was the preservation of business relationships. Remember the point I made about the win-win outcome? The users, and this survey was an influential survey which polled over 300 corporate and external counsel for the period 2016 and 2018. And this is a point worth paying attention to, that preservation of business relationships was certainly top of mind as a reason for choosing an appropriate dispute resolution, and no prizes for guessing which modality had that feature. So I will pause here and pass the time back to the facilitator for the question and answers.
Thank you, Mr. Vijyendran, for sharing these thoughts on the future of mediation and the Singapore Convention. There are many questions which have come our way. I do not see anybody having raised his hand, so I will just quickly put the questions which have come on the chat. So the first question put is, to what extent do you think the lacuna in effective communication could imbalance the level playing field of a mediation? And can awareness in technology alone fix it, or certain other measures other than technology should also be figured out? That's the first question.
Okay, so is that question also on the chat?
Yes, it's on the chat.
Okay, so let me just scroll.
It's the first question on the chat.
I see it. Yeah, from Soham Shri.
So much.
Yes. I think you raise a good point about the lacuna in effective communication, and I think one has to be diagnostic about it. What is the source or the cause of that ineffective communication? Is it a trust issue? Are people putting their cards on the table in the mediation because they consider it to be a safe environment? Or are there barriers to that communication because of a trust issue? Or people do not want to be candid, and so that goes towards a deeper psychological point of good faith as well. And having been mediation counsel as well as mediators, I can also say that there are people who do not always come to mediation with good faith. And sometimes, there are people who try and game the system as well, where they may be there to size up the other side because they're going to be cross-examining a particular party in litigation, and they're there for collateral reasons. But and so the good faith is a fundamental feature, and that could be one barrier. Now, obviously, language is another barrier. And we need to make sure that the interpretation piece is taken care of. Now, what about parties that are, for instance, more diffident, and other parties that are, very domineering? This is where the mediator needs to ensure equal airtime, and that there's a structured process where it will give essentially an opportunity for everyone to participate in as equal or an even-handed a way as possible. So those are some examples, and not exhaustive. They need to be tackled. They would apply whether on site or online, that's for sure. Now, yes, and so then it follows from that answer that can awareness in technology alone fix it, or certain other measures? So you can tell from that answer that there needs to be good faith and trust all around. Technology per se is not going to solve a trust issue, and it's not going to certainly bring about the right chemistry and the kind of right mindset that may be involved in mediation. Going back to the example I shared of the cross-border dispute, I was in the happy place that not only my co-mediator, but the parties and the counsel were all committed. And one of the things I always say at the onset of a mediation is to the counsel, is that we are all going to solve this dispute together. So let's put on our problem-solving hat. And you need to make them feel a part of the process and to own the solution together. But anyway, those are probably only scratching some parts of the surface of this question. It's a very deep one, but short point, tech alone can't solve some of the other issues that we touched on.
So if you just scroll down the next question, you will see is that in the Singapore Convention, what is the difference between the nations that have signed and the ones that have ratified? Why did Singapore not sign? Is there a significance to this?
Actually, Singapore signed, and Singapore's name is up in that slide that I shared as well. It also ratified, and so I think the numbers are actually very minimal in terms of requirement for a treaty to basically be recognized, as a convention, and then for a treaty to come into force, you need to have only a minimal number ratified, and I think it's something like 3, and I may stand corrected on that. But the point is that it's essentially a case of the more the merrier, because it will result in an enhanced enforcement in the jurisdictions that are parties to the convention. And so the difference, of course, is that if you ratify, then the essentially that you are confirming that you will not only be a party, but subject to any of the declarations that that you may be also stating at the time of ratification, that you are prepared to essentially implement the enabling legislation in your own jurisdiction, and for this to come into force. And so that's the distinction between the signing and the ratification.
Okay. So the next question, again by Soham Shrit, is: will the Singapore Convention on Mediation operate retrospectively or prospectively? And what about those mediation undergoing in process before the convention comes into force?
Right. So the short point is that it will operate prospectively, not retrospectively. And as for mediations that are undergoing the process of mediation before the conventions come into force, obviously, if it's completed, then the Singapore Convention on Mediation will not essentially be applicable to it. But the point of the mediation convention is that you can of course take that consummated mediated settlement and force it by way of the court order as a shield in case that you are sued in your own jurisdiction. And of course, if there is a problem with enforcement, you can then take it and then enforce it in the overseas jurisdiction. And so you have got, in a sense, a more prospective type of solutioning for the convention. And it will be, of course, very much something that will apply when your country would ratify. And the ratification piece is only something that can only be done if you have got enough enabling legislation within your own jurisdiction that is implemented. And so that is really the short point here. There is still a before and after aspect, and so that will be very much the way in which this will operate in the future.
Well, so the next question, although I think the answers that you have given answer this question too, but still for the benefit of our keen participant, whether Singapore Convention on Mediation Act is applicable internationally.
It is meant to apply to international settlement agreements that involve commercial disputes. So that is very much the intent. And so it's not meant to apply to domestic mediations. And of course, insofar as the question is asking about the applicability in terms of going forward, then of course that is very much a future piece.
So the next question by Masoom Rathod, even though it does not strictly pertain to today's session, but I think just for her benefit, if you could just answer it. Question is practically, which is the better way of dispute resolution among mediation and arbitration? Even though I'm sure that some of the other sessions previously would have taken care of this, but if you could just once again answer.
Right. So I go back to a fundamental touchstone about appropriate dispute resolution. And it's really very much the right tool for the right problem. And so you would be, I think, well placed if you are skilled in litigation, arbitration, and mediation, because then you can pull out the right tool to be able to advise as well as to utilize to resolve the matter. And that gives you the breadth, but it also gives you the depth. So the appropriate dispute resolution piece requires you to consider aspects such as, for instance, enforceability, as well as aspects such as the reputation management, or even the confidentiality, which would apply both to arbitration and to mediation. Are you looking for an adjudicative process, in which case you would go for arbitration? Are you looking at something in which it's more facilitative and the parties will work together to try and bring about a resolution, in which case it's mediation? And then you would also want to pay attention to aspects that relate to for instance, the subject matter that is involved, and to what extent would it be arbitrable? To what extent would it be amenable to mediation? So you need to consider this in the round. If you are trying to analyze at the front end, if you're trying to introduce as a sunset clause or standard boilerplate clause, mediation versus arbitration clause. One approach might be to do a med arb as a multi-tiered dispute resolution clause. So you do for mediation first, and if you cannot achieve resolution, then you can escalate up to an arbitration. But that's very much at the front end. In terms of selecting the right fora at a dispute phase, you should consider some of these points that I just touched on. Consider time as well, because mediation has this big advantage of speed, which is also something that is not replicable in either arbitration or litigation. Litigation, of course, depends on the time that the court case will take, and arbitrations may also take, in some cases, years, whereas a mediation could be stitched up in a jiffy, all the more so if it's tech enabled.
So the next question is by Veena Shankar, and it's a very interesting question. Question is, it is with respect to co-mediated sessions. If any one of the two mediators come across more dominating, will it affect the final results of the mediation session, especially during international disputes?
That's an excellent question.
Yes, very interesting.
Yeah, that's an excellent question. So I think there's a risk factor, because if you're doing it jointly, then you're only as strong as your weakest link, really. So, if one mediator has misbehaved, inverted commas, and crossed the line in terms of trying to foist a solution on the parties, unfortunately, I think it will infect the mediation. And so there's going to be as it were, a tainting by association, and this would be a risk factor for a setting aside. So both mediators would need to adopt the right standards, the right ethics, the right ethos as well, and ensure that you do not compel the parties. And you must remember that in some of these settings, the parties, or at least one of the parties, may be looking to game the system. So if your antenna is up, you will also know that some parties may walk out of this without any intentions to comply, and then they will seek to torpedo it, later on. So it's best to be prim and proper.
Okay. The other question, and I think this is probably would be the last question. This is by Advocate Savio, And the question is, mediation is without doubt a unique mechanism to settle disputes. But in an online mediation, is there a possibility that co-mediators, especially from different countries, could be in conflict with each other? In such a situation, if such a situation occurs, how can that be resolved and by whom? Another interesting.
Yes. When you say conflict, I presume the assumption here is that, they may actually have a different view on say, particular point on the mediation, whether it's in terms of what needs to be said, or in terms of, say, option generation, or even in terms of, a particular feature of the mediation. So the deeper point here is how to have a de-escalation or a mediation between the mediators, and finding a way to deal with these differences. So the way that, for instance, I worked with my co-mediator and I work with co-mediators is, essentially to try and plan ahead of time, preempt, think through, ensure that you are both aligned so that when you go in, it's a united front. So that is, of course, what you can do. But what happens if there really is a conflict? I think one way is that you both have to be in communication. You have to have your private channel of communication to say, look, can we do a timeout? And we go and discuss in the mediator's room, and we'll come back again, and then you trash it out. The last thing you want is for dissonance or differences of views, because that's a recipe for disaster.
So there is one more question. And the question is, India is yet to pass and notify its Mediation Act. As such, how Singapore Convention can be implemented in India in case of an international commercial mediation?
So the short point is, you can't, until and unless you have the domestic piece. And that's also why you will see that I was showing you the slide earlier, that 55 countries have signed, including China, India, US, but China, India, US have not ratified, because there is going to be some hard work in basically enacting the domestic legislation. And we all know that there is going to be a difference in terms of speed and pace, and the internal stakeholders to be consulted before a law is made in different countries. Countries, where you've got federal state, consensus that's needed and so forth. And so we're just going to have to play the long game on this. In as much as, Kazakhstan is the latest to ratify, but, there will be others, and it will be a journey, and, they will continue to grow. But the tough piece is to get your teeth in terms of the domestic legislation in place. And so until and unless you have that, you really cannot see the fruits of the convention being reaped for our respective jurisdictions. What is the appeal mechanism for ambiguous settlement agreement under the Singapore Convention? Okay, now that's an interesting point, because you remember I talked about one of the grounds for refusing relief being the lack of clarity and the lack of comprehensibility, where the obligations are not clear or comprehensible. And so in that situation, you're left back to square one, because relief will not be granted. So how do you deal with ambiguity? I think we fall back on contractual principles. Is there a way to resolve ambiguity? Can you get a declaration, for example, that that this is the purport or effect of a particular clause? You might have to take that intermediate step, or to have some variation, or perhaps even to go back to the mediator. And some mediators are prepared to have further second bite of the cherry or even a longer tail in terms of the mediation process, and might wane with their wisdom on how something ought to be interpreted based on the way the parties had approached it. And sometimes you do have that. I mean, we offer that, for example, as mediators before mediation settlement is inked. And so we say we're always available if you want to talk to us and get guidance on anything. But sometimes exceptionally, even post settlement agreement in writing. But that piece needs to be resolved. I don't think there's a mechanism where you can have that on appeal, because there is no way to divine the party's intentions. You're stuck with that. So you have to fall back on cadence of construction. You might have to fall back on contra proferentum. You might have to figure this out either contractually or through some of the practical processes I mentioned.
There is one more question. It says, since communication is one of the most important factor towards harmonious settlement between the parties, do you think communication via online mediation is more challenging in understanding the emotional side of the parties sitting at faraway places? Does private caucus help solve this problem?
Yes, I think you have sort of opened up another flank, which could get me talking for hours, but I won't, to spare everyone. I will just give you some succinct points. I think you're spot on in asking this question, because there is an emotional aspect, and particularly for some kinds of, frankly, even for commercial disputes, there is obviously tensions, disputes with involve that. And so how do you decode the emotions of parties if you're zooming in and out like now, right? I can't tell whether you're feeling bored or angry or upset or hungry. You can't. And so, that's tough. And you probably have to be very observant. You probably have to check in, use a fair bit of EQ. And in terms of the underlying emotions or perhaps some of the emotional baggage in the dispute, I think in the private caucuses, as is suggested here in the second part of Utsav Singh's contribution, that could be one way. So I find that the private caucuses or the breakout rooms, not the break up rooms again, but it's where they can vent. And sometimes, frankly, people need to vent. And I think, it's also helpful. It really gets the emotions out of their system. And you should do it in a private caucus so it doesn't become dysfunctional or toxic. But, give them the space. If they want to say exactly how they feel, let them say it. And, you listen. And sometimes you're just, you're also speaking to that and getting them to look at it from a big picture perspective. I agree, it's far more challenging. And sometimes, I think this is where the in-person mediation probably has some advantages. So not impossible, but it is challenging.
I think that's no. There is one more question which is there at the end. It says, Mr. Vijyendran, you spoke about collaborative mediation. Can you please elucidate more on cross-border collaborative mediation? How can a young advocate or a medium-sized law firm in India collaborate with counterparts from other countries? How can we take it forward, and what is the right approach?
Okay, so ideas. Well, for number one, build your international law network. I mean, look at this gathering. I'm just amazed that we have friends from all over the globe. So kudos to Livaran. But there are many other settings as well. There's the AJIA for young lawyers. You get IBA, the Inter-Pacific Bar Association, Law Asia, Commonwealth Law Association, which does a wonderful job as well with young lawyers. And so build your international law firm networks, or at least build some of the best friend relationships with, lawyers from other countries, and maybe with people from your own vintage and peers as well, and see whether you can explore a model where you could co-mediate. Of course, do get the training. Training is critical. Although this may look like an easy mode of dispute resolution, you can ask the seasoned mediators here that it isn't. So training is vital. The quality control is vital. The ethics, the ethos. Remember the pitfalls that we talked about in the course of this lecture as well, of mediator misconduct, and it came out in the Q&A as well. So you don't want to go in and have a misstep, and then that could be disastrous for you reputationally and others. So invest in training. Nivaran is doing a wonderful job. But build your networks, and then why don't you experiment? If you've got a friend from another country and say there's a cross-border dispute between that country and yours, why don't you both offer a mediation service? So maybe, for example, instead of doing the litigation, that could be something you could offer the client, and say, look, I have this friend and they're in this country. Would you be open to a co-mediation of this dispute if there is agreement all round? And sometimes you never know. There may be some practical opportunities. Of course, you have to market. You may have to see how to use tech and so forth. But consider this, and again, the world is your oyster, as I showed in that last slide.
I think that takes care of all the questions. But sir, just one. I have just one query. You said, sir, that once a country ratifies the Singapore Convention, then what it necessarily means is that it subjects itself to the provisions of the convention. Now, having ratified the Singapore Convention, a country enacts its own domestic law. Sir, there are many compulsions which go into drafting a law. The legislature has various compulsions, maybe pressures from trade bodies and commercial institutions. Now, in a situation like this, if there is a conflict between a provision of the domestic law and the ratified convention, then which prevails? Or what is the solution?
Well, that is it's a deep point. So we go back to first principles as well, because and just to unpack a little bit about I think the question of signing and ratification. Signing, of course, is almost like an in principle agreement, and you basically are supportive. It creates a negative obligation not to defeat the purpose or object of the treaty from the time of the signing till the time of ratification. And ratification, of course, is the legally binding step. And it commits the country to implement the convention. And it will be subject to reservations. We touched on that in the earlier slide, declarations and understandings. So I think before you take the step internationally or ratification, oftentimes a lot of the domestic pieces need to be put in place. They've got to be lined up, the ducks in a row, because what if you hold yourself out and then you're unable to do it? You will be in breach of your international law obligations under the treaty. And then that creates another set of international law problems for that nation involved. So I think the prudent step is to put in place and to ensure that there is alignment, and perhaps that's why some countries would have declarations or reservations, or maybe even a kind of hedge, to put it in colloquial terms, the position where there is a need for some degree of clearances. But I think it's a journey, and I think that in most of the cases, the buy-in needs to take place, the consensus needs to take place in that country, and there will be circumspection about the ratification step unless there is internal consensus.
So if there are no more questions, then let me close the session and propose a vote of thanks. Any more questions? So there are none. So thank you, Vijyendran sir, for sharing your thoughts with us and clearing our doubts in the question and answer session. Participants, you've just heard Mr. Vijyendran on the future of mediation, on the Singapore Convention and legislation and mediation. And I'm sure we are all have been greatly benefited, and we go back much wiser today as far as knowledge on these topics is concerned. Mr. Vijyendran, with regard to online mediation, he talked about its advantages and issues. And one very interesting observation of his was that in this COVID pandemic, online mediation has shown its agility and nimbleness in how quickly it adapted to the changed circumstances. And mediation was never closed, even during the pandemic. The other advantages of online mediation, which Sir has put across, is that there are no geographical limitations. Once you come down to online mediation, there is cost saving, there is time saving. It is logistically efficient. You are at home, you're not traveling all over the world for it. And of course, the psychological factors, that is, it reduces tensions, and it is a leveler in terms of power dynamics between parties, as in the case of an individual vis-a-vis an MNC or an institution. So as far as Mr. Vijyendran is concerned, the future of mediation is e-trend. That is where we are heading. On the Singapore Convention, he gave us a lengthy presentation and took us through the various clauses, of the convention. And he also told us that the Singapore Convention actually came about seeking to address the key obstacle in enforceability of cross-border mediation agreements. As far as the future of mediation is concerned, according to him, the future lies in online mediation, in collaborative mediation, and in the growth of what we would now have, specialist mediators. So thank you, Vijyendran sir. Thank you so much for sharing your thoughts with us. I now propose the vote of thanks. On behalf of Nivaran, I thank all the participants for so keenly attending this summer school 2022. Your attendance in all these 9 days, your keen participation and your very insightful and penetrative questions give us at Nivaran the encouragement to continue this program year after year. I extend my gratitude to all the senior members of Nivaran who have given so much of their time and effort in making this summer school a success. I also propose a special expression of gratitude to Mr. Brian Spears, President of the Commonwealth Lawyers Association, and Mr. Peter Maynard, the Vice President of the Commonwealth Lawyers Association, for their presence during these sessions. Needless to say that there is a special vote of thanks due to our technical backbone, that is Rahul and his team, for keeping us connected seamlessly these past 9 days. Thank you all so much. Now, before I close this last session, I extend a very warm invitation to all of you, to all the participants, to please participate in our closing ceremony tomorrow evening at 5 p.m. wherein our chief guest will be my Lord, Mr. Justice P.S. Narasimhan, Judge of the Supreme Court of India, and the guest of honor will be Mr. Brian Spears, President of the Commonwealth Lawyers Association. So, hoping to see you all tomorrow at 5 p.m. Thank you good evening, and wishing you all a very happy Independence Day as we celebrate the 75th year of our independence. Namaskar and Jai Hind.
Thank you so much. Thank you, Gregory.
Thank you, Vijyendran. Thank you.
Thank
Anil.
you, President Gregory. Thank you so much.
Thank you, everyone.
Good.
Thank you,
Thank you
President
so
Saldan.
much.
Thank you, colleagues.
Great